All right, Joey, are you ready? All right. Yes, I'm connected. I can see you. All right, we're on the record in cause number DF 23044423. Councils, will you please announce for the record?
Chris Cantu on behalf of Ebby Maida.
Thank you.
Nicholas Smith on behalf of respondent Katrina Shaw.
Thank you.
Justin Bell, AG's office.
Thank you. And just so the record is clear, the respondent in this case, Katrina Shaw, she was noticed to be here today for final trial, and she is not present. And counsel has represented to the court that he doesn't know where his client is and was informed that she would not be here today. Is that correct, counsel?
That's correct, Your Honor.
All right. So prior to going on the record, we noticed that there was a de novo appeal filed, a request for a de novo appeal filed, and it was set week after next, which is after the trial setting for today. And both counsels have agreed to go ahead and have that appeal conference today. Is that correct?
Correct, Your Honor.
Yes, Judge.
All right. So in review of the appeal conference, it looks like there was an appeal, Mr. Smith, by your client on petitioner's motion for a protective order as a discovery sanction. Is that correct?
Yes, Your Honor.
All right. So let me get the clock going here for you all. And before we start, did you all submit any exhibits for that yet? Or is that what the conference was going to be for?
I would assume that was what the conference was for.
So the conference, Judge, was your exhibit conference for trial, which only I showed up to. So I submitted my exhibits and Judge Lee said, my exhibits are admitted and nobody else was there.
Okay.
And then we noticed that there was the conference that was set on November 3rd and said, she was like, oh yeah, definitely bring that up to Judge Bailey because she didn't understand why that was after the trial as well.
Okay. All right. So I'm going to give you all 10 minutes aside for argument, essentially, because I don't have any exhibits for the de novo appeal. And Attorney Smith, this was your client's motion, so I will start with you.
Thank you, Your Honor. Your Honor, we filed the de novo appeal in regard to the motion for protective order that was presented by petitioner in response to our service of discovery. There was a hearing set on August 28th, 2025 for the motion for protective order. We received notice of the associate judge's ruling on September 2nd and filed our de novo appeal on September 5th, which would make it timely filed in accordance with Family Code 201.015. The reason why we appealed that de novo conference or filed the de novo in response to the protective order ruling is because the protective order or the motion and the subsequent order on the protective order served as a sanction against respondent rather than issuing a protective order in regard to the discovery served. Texas Rules of Civil Procedure 192.6 permits a party to seek a protective order in regard to discovery regarding the time or place of discovery or to protect the movement from undue burden, unnecessary expense, harassment, constitutional property rights, any of those things. None of those were alleged in the motion for protective order. If the moving party demonstrates that protective order is necessary, or that the discovery sought creates an undue burden, unnecessary expense, harassment, etc., the court may issue rulings in regard to that discovery not being able to be sought in whole or in part, ruling against the discovery having to be answered, limit the discovery that's been served, order that discovery not be undertaken at the time or place specified, or the discovery be undertaken only by such method or upon such terms and conditions or at the time and place directed by the court. Per the rules of civil procedure, there are no means for the court to sanction a party in regard to a protective order, to strike a party's pleadings in the entirety of the case in regard to a protective order, or issue attorney's fees in regard to that protective order sought. And all of that, I believe, was done outside of the scope of the permissible rulings that could be undertaken by this court in regard to a protective order against discovery. And that is why we had served our notice of de novo appeal in this, Your Honor.
Okay. Attorney Cantu?
Yes, Judge. So I guess I'll just begin with 192.6, which is the motion I filed for a protective order, which clearly states that anybody who served discovery may move within the time permitted to respond to that discovery and request protection for that person from the discovery sought. That is exactly what my motion laid down. And it's interesting for Mr. Smith to say, well, his motion didn't say any of that. Judge, I would just like for you to take judicial notice of the court's content and file in my motion, which lays down exactly why I filed it, including the injustice that has been served on my client from a mom who has removed these kids from Texas, their home state, for over a year and a half, and then thinks that she can be ordered by this good court to appear to court several times and not do it, and then think I should be able to serve discovery shortly before trial.
The court takes judicial notice of all contents of the court's file.
Thank you, Judge. In there, in the motion itself, to protect my client, the judge only has to see if whatever happened during this case has been harassing, has been burdensome, has been inappropriate. She can consider all those things. And to protect my client from any undue burden, any unnecessary expenses, which I believe would be extremely unnecessary expense for this mom who didn't even show up today to say, I need to serve discovery when I don't listen to the court. Anyway, we had a hearing on it, Judge. And under section B of 192.6, the court may make, this is very important, it says the court may make any order in the interest of justice and may, among other things, order that the requested discovery not be sought in whole or in part. Again, one of the things that the Judge Lee could do was stop the discovery, say you can't serve any discovery. She may do any order, that's what it says under 192.6 under protection orders, the motion I filed. She may make any order in the interest of justice. When I presented my motion and counsel didn't show up, his client didn't show up, I presented the evidence of what was been going on in this case, and Judge Lee saw fit to order exactly what she could order. No discovery, attorney's fees, which in family law can be ordered for any motion. It's in our code, and to strike pleadings. The other problem with this is counsel is arguing that she struck pleadings, but they have no pleadings. They've never filed any motion, or I'm sorry, any pleading, any petition, any modification. They've never had any pleadings for over a year. So I guess the argument is, even though we didn't show up, we would like for you to overturn what Judge Lee did, even though it was in her power to do it, Judge. So I believe that this de novo should be denied. Judge Lee had the power to stop their discovery, to order attorney's fees, and to sanction her for trying to use discovery, even though she has not been cooperating with Judge Lee's orders. That's what I presented at the motion. And that's what at the hearing, and that's what Judge Lee considered. And so yes, Judge, this de novo is kind of ridiculous. And once again, the respondent's not even here. So somehow to say that that's affecting their trial, that had no effect on them being able to present exhibits or showing up to any motions or showing up today or showing up to the exhibit conference and then trying to introduce any exhibits. That has nothing to do with anything. And they've never had any pleadings on file.
Thank you. Mr. Smith?
Nothing further, Your Honor.
Okay. The court does have a question. There was an order for substitution. I did just sign it. I want to make sure I state that for the record. I did officially just sign the order of substitution of counsel that was filed way back in like March or April of this year. Since you have been on the case, why haven't you filed any pleadings?
I can't answer that, Judge.
Okay. Excuse me, has your client, well, I mean, without violating any type of a current attorney-client privilege, is it your understanding that your client does want to participate in this case?
Yes, I would say it is my understanding that she does,
Okay,
but arguably from actions, I think that might be a little different.
all right. Okay, so anything further?
Nothing further, Your Honor.
All right, so the court is going to deny the de novo appeal. So we've taken care of that. In regards to the trial setting for today, counsel, Attorney Smith, I noticed that you did file a continuance for your client.
Yes, Your Honor.
However, based on review of the court's record and just your client's behavior, it would not be in the best interest of justice to delay this trial any further and give these parties some relief. Because if the court is under the impression that if I reset it, we would be in the same circumstance again.
Yes, Your Honor.
And I don't think that's a good use of anyone's time. So the exhibits that I have from Dad are exhibits 1 through 16, and they are admitted. And it's my understanding that your client has not presented any exhibits.
That's correct, Your Honor.
All right. So, sir, would you please raise your right hand? Do you swear or affirm that the testimony you'll give today will be the truth and the whole truth?
Yes.
Okay, thank you. We are set here today for a final bench trial on the suit affecting the parent-child relationship. You all are set for 30 minutes aside. You may give any opening statement and any closing statement should you choose to do so. However, that's totally within your discretion. But it will include any examination that you do as well. And state, I'm setting your clock as well. I know you're standing over there, so I don't even know if you, is there any objection for the state to go first?
No objection.
None, Your Honor.
Well, Judge, I'd like to raise this important question that I realized this morning. So this did originate on the state's motion to modify the confirm arrears. Parties had an order a couple of years ago that did not set child support because parties were living together. There was medical support order and government health order at that time. There was a temporary order during the litigation that set father's child support to 80 or 89, I believe. And that was on in October of 2024.
Mm-hmm.
After review of the OAG system, that temporary order was never sent to OAG by any. As such, I do not have a current accurate pay record as to any arrears father may or may not owe at this time. The medical support that was ordered prior to this litigation has stopped because the temporary order ordered mother to carry private health. So there's no current medical support at all. He does owe a little bit, which came from a couple of years ago. So my point is, there's no current pay record. Ordinarily, I would provide one as an exhibit from arrears. I don't know if father's been paying mother directly, and she's not here to ask about that. Since we're proceeding today, I have no problem with the state simply non-suiting its request to confirm arrears, which worst case scenario, father hasn't been paying his child support arrears would be 289 times 11 plus some interest, so not a whole lot. And the state would just proceed to confirm arrears with 4D later, unless there's something that I don't know the parties know.
Just briefly on that, Mr. Dale is correct. So in October, what happened was that was when Judge Aguilar asked her to come back She didn't. So she actually was ordered to pay child support in that October order.
And I was looking at that, we're referring to the order that is, it's like 32 pages long.
20, I have it at 29, Judge, on, yeah, she was ordered to pay 289. And it was signed by Judge Aguilar on October 17th, 2024.
Okay,
And it was Miss Phillip that was on the case at that point. She appeared too. So it was mom that was ordered to pay child support.
Yes, excuse me, it was mother. Even so, Judge, the state would like to not prosecutor for father arrears today, as there is minimal medical support arrears, and is happy to proceed on the child support issue only.
okay.
Thank you.
You're welcome. The court accepts that request. Attorney Dale, are you gonna give me an order pursuant to that, the non-suit?
I would typically, I can just include that language in the final order.
That'll be good. Okay, thank you. All right, so the issues that the court is proceeding on today will be child support, possession and access, conservatorship, and attorney's fees.
Yes, Judge, on our end, yes.
Okay, all right.
And I'm sorry, just a brief opening if I may. I know I don't.
Sure,
I don't have
go
a lot of
ahead.
time, but yes, just this has been I believe the evidence will show, this has been a very difficult case for my client. This is a case that started in 2024. Mom absconded with the children, appeared and told Judge Aguilar that she was gonna come back. We reset, she doesn't come back with these kids. All the while, my client's not being able to see his two kiddos. We get in front of Judge Lee for a pretrial. Mom appears via Zoom on that one. Judge Lee orders her back because we have stand live pleadings over here, which is part of our evidence to show that there was temporary orders that she would not obey. Judge Lee told her, gave her a week to come back. Instead, she sends an attorney. The attorney says, I don't know where my client is. So Judge Lee, we again resets, hey, she needs to come back. At that point, in between the reset, we learn of a Philadelphia case that mom tried to start. And the evidence will show that after a judicial conference, which is under P2, I included the order from Philadelphia, wherein that judge found that the mother was lying to her and she dismissed all of her cases and was once again told to come back to Texas. My client at this point still hasn't seen the children, and we're getting into 2025. We set 3 more hearings, Judge. Another attorney appears for her. She has not appeared. The evidence is going to show that my client has paid me a lot of attorney's fees to get these orders done, to try to get mom for a sheriff to remove these children from Philadelphia, but she was too difficult to find to come back. So today, Judge, we believe with the evidence that we're going to show that this court needs to find that Texas is the children's home state. My client needs to be sole managed conservatorship. Mom should have no visits or supervised visits, and should have to pay a bond to secure any possession access. This is one of those rare cases, Judge, that it doesn't matter what any court tells her, she's not going to listen. We need an order with teeth so we can get the right authorities involved if need be. I will say that luckily, my client has told me the kids are back. They're actually with him and he wants an order so that way this can't happen again. He is finally able to see his 2 girls. We brought pictures of them together recently. They're going to a school right by his house. Just sheer luck, not because she was arrested and the kids got back. He has the kids back. She brought them back. And we need an order so this cannot happen again. And once again, Judge, she's not here. So there is a concern that none of this matters to her. And we need the court to have a strong order, which we believe through our request for relief and our proposed parenting plan is in the best interest of the children. Thank you, Judge.
Thank you. Attorney Smith,
I'll waive opening, Your Honor.
okay, and Attorney Dale.
I'll wait.
All right, Attorney Cantu, you may call your first witness.
I call my client, Mr. Maida.
Okay, Mr. Maida, if you'd have a seat right here, you can just come this way. And make sure you see how the microphone is right here on me? Make sure you pull the microphone close to your mouth. There you go. When you're ready, counsel.
Thank you, Judge. Mr. Maida, your name for the record, please.
My name's A.B. Maida.
And we are here talking about your two kiddos, Sienna Shaw and Everly Shaw, correct?
Yes.
And what are they, 9 years old and 6 years old?
Yes.
Prior to, I know recently the children are back living with you, correct?
Yes.
And has that been amazing?
Yes, it has.
How long had it been since you had seen the kids?
A year. A little over a year.
Throughout the pending, you heard my opening, you've heard what's happened. Is it true that at least since July of last year, maybe even a little before then, you hadn't been able to see your kiddos?
No, not at all.
And is it true that on two different occasions, at two different hearings, Miss Shaw, the mother, appeared and stated she'd be bringing the kids back?
Yes.
Is it true that we've had several orders for her return to bring the kids back?
Yes.
Throughout their lives, their young lives, has Texas been the only place where they had actually permanently resided?
Yes.
What we have already pre-admitted as P1 is your requested relief. Today, you're asking the judge to actually grant your proposed parenting plan, correct?
Yes.
Your proposed parenting plan, as what has been pre-marked as and admitted as P16, lays out conservatorship, possession, access, and child support, correct?
Yes.
In there specifically, as Judge Lee and Judge Aguilar have already ordered, it orders you as the sole managing conservator, correct?
Yes.
And as Ms. Shaw as the possessory conservator, correct?
Yes.
Do you believe that, and you see that Ms. Shaw is not here again, correct?
Yes.
Do you believe it's in your best interest of your children for you to be the sole managing conservator of these kids?
I do.
Do you believe that mom's behavior this last year and a half of absconding and keeping the kids away from you, was that good or bad for your kids?
That was bad, terrible.
And you do realize that she tried to file lawsuits in Pennsylvania, correct?
Yes.
And you had to pay me to find her lawyer, find what court she was in, and ask for a motion for the judges to confer, correct?
Yes.
You participated in a hearing with the judge from Philadelphia, Ms. Shaw's lawyer from Philadelphia, and Judge Lee, correct?
Yes.
And after all the evidence was presented, it turns out that there was no proof of mom living in Philadelphia longer than a couple months, correct?
Yes.
In fact, you've had pictures of you guys living here in Texas for the last 3 years.
Correct.
In this requested relief, you're asking for the judge to find that the home state of the kids is Texas, correct?
Yes.
You are also asking for the judge to find that there is credible evidence of Miss Katrina Shaw abducting and absconding with these children as she's done in the past, correct?
Yes.
You want the judge to find that she has previously disobeyed these court's orders, correct?
Yes.
You want the judge to enjoin her from hiding or secreting the children, correct?
Yes.
In our request for relief in this proposed parenting plan, you're also asking that she be prohibited from herself or anybody in concert with her removing these children from Texas and the United States, correct?
Yes.
And you were requesting that Ms. Shaw execute a bond of at least $10,000 in case you have to, once again, try to locate her and get these children back to Texas, correct?
Yes.
You are asking for Ms. Shaw's visits to be supervised at Hannah's house on the second Saturday of each month from 10 to 2, correct?
Yes.
Or for the court to order what the court believes would be a visitation for the kids and mom that would be in the best interest of the children, correct?
Yes.
You would also like a permanent injunction against Ms. Shaw from removing the kids from any schools they're going to, any daycare facilities they may go to, correct?
Yes.
You are asking for Ms. Shaw's child support. She's was ordered back in October to pay you child support. Has she paid any child support since October?
No.
You are asking for the court to order her to pay child support based on minimum wage and for her to be paying $294 per month with the first payment due November 1st of 2025, correct?
Yes.
And then after your eldest ages out per the Texas Family Code, for that to drop down to $234 a month, correct?
Yes.
Besides the security bond for potential risk of international abduction, you would also ask that prior to mom executing any visits that the court may award her, she post a cash bond with the court of $5,000 so we can ensure that she understands that these orders should be followed, correct?
Yes.
And we are also asking that you apply for some kind of medical care, whether it be through your job or through the state, within 30 days so you can get these kids on medical insurance, correct?
Yes.
And that mom pay cash medical support, which has been laid out in our proposed parenting plan, correct?
Yes.
What school are the kids going to right now?
They are going to Uplift here in Grand Prairie.
They're like in school.
Yes.
Did they start on time?
Yes. They started on time.
We have what has been pre-marked as P9 and P10 and pre-emitted pictures of their room that they have at your house, right?
Yes.
And you have what your mom, who lives with you besides your kids? Your mom?
It's like it's two different houses. So like our house is in the front, theirs is in the back. So I mean technically, yeah.
Okay,
They
so your
live
mom's
with-
there. So you have help.
Yes. Yes, I do.
They love grandma.
Yes.
They got a good relationship with her.
Yes.
And then you just recently were reunited with your daughters. You have some pictures, which were pre-marked as P10. That's recent pictures of you and your daughters at the house, correct?
Yes.
Happy to see their dad.
And they were very happy.
What's been pre-marked as P13 was the order to return that Judge Lee signed. She gave the mom about a month to return these kids and then finally signed an order to return them, correct?
Yes.
You were present at the hearing, the pretrial hearing, where the mother, told Judge Lee she picked a date and time that she'd be back with the kids. Do you recall that?
Yes.
Judge Lee reset the hearing. Did mom appear at the date and time she said she was going to bring the kids back?
No.
Instead, she sent a lawyer, correct?
Yes.
His mom appeared. We've had 5 settings in this case. Has mom appeared at any of these settings?
No.
Do you have a fear that if you don't get an order with the requested relief you have, that mom can just take the kids again?
Yes, I do.
Do you believe that this order would give you enough enforceability to ensure at least a better shot at getting these kids back if mom were to abscond with them again?
Yes.
Sir, in here, under your requested relief, you're also asking for the court to confirm that Ms. Shaw owes $2,023 in child support arrears based off of the October 2024 temporary order signed by Judge Aguilar, correct?
Yes.
You're asking the court to confirm that arrearage and grant it as a judgment against her and in favor of you, correct?
Yes.
In here, you've laid out a payment amount, a date, time, and location for mom to pay it in your requested relief, and you're asking the judge to grant that as well.
Yes.
You also want the court to confirm that through the temporary orders and sanctions that Judge Lee has assessed against Ms. Shaw, she owes $3,000 in attorney's fees, correct?
Yes.
That's already been ordered. You're asking the judge to confirm that amount and make it a judgment, correct?
Yes.
And that's also in your requested relief under relief request number 3.
Yes.
Sir, throughout this case, you have had to pay, aside from the $3,000, not including the $3,000 that you're asking the judge to confirm, $20,570 for the 6 hearings you've had, correct?
Yes.
For trial, correct?
Yes.
For the motions, and one of them being with a judge in Philadelphia, correct?
Yes.
You have paid my office. You've worked hard for that money, correct?
Yes.
And you're asking the judge to grant you an attorney's fees judgment in that amount.
Yes.
And you're asking that to be awarded to you and against Ms. Shaw for $20,570, correct?
Yes.
Do you believe that your requested relief and your proposed parenting plan are in the best interest of your 2 children?
I do.
I'll pass the witness, Judge.
All right, Attorney Smith.
No questions, Your Honor.
Okay, Attorney Dale.
Mr. Hager, you're asking that mother be ordered to take a child support based on the mortgage, correct?
Yes.
You know, do you have any personal knowledge of whether or not she's employed currently?
She's currently working, I believe it's a daycare. I think the name of it's called Little Rascals. Yes. I would say maybe at least 2 months or so. Um, well, I've been to her job before, so other than that, and I mean, I've seen her paychecks, and I mean that's it.
When's the last time you went to the job?
About a month ago, I went there to pick up my daughter. And she wanted to show me how much she made. Um, if I had to guess, I'd say like maybe 4 weeks ago, around that time.
You recall
I believe it was 1,300.
pay period, how often she stayed?
It's every 2 weeks.
So you know, she has the other,
No.
that her net income, like,
Yes, I believe so.
what kind of funds?
They have Molina Healthcare. No, I believe her job I think provides. Yes. Probably around 2 months or so, like when she first got the job. Yes.
You have credit cards?
No, sir, not on me.
Well, has she provided that
No.
since the girls have been living with you at the doctor?
No.
You providing her girls health insurance that's gonna be in this final quarter. Are you asking that she be ordered to continue to maintain this health for her job?
Yes.
And do you have any idea how much that costs for this monthly grant?
I have no idea.
No, where she's working, what,
Before this, she didn't have a job here, so it was somewhere over there in Pennsylvania, but I forgot what it was called.
where's the daycare?
It's here on Crocker Hill.
Would you like her to pay other job based on $1,300 every 2 weeks as for,
Yes.
are you currently employed?
Yes, I am. I work for my dad's company actually. It's a trucking company. He pays me by the load. So it depends how many loads I do a day. 500.
W-2 employee or?
1099.
Do you have any other?
No.
All right. Attorney Cantu, anything further?
Just briefly, based on Mr. Dell's questions, sir, in our proposed parenting plan, it stated that you apply for insurance, but you would like to modify that and ask that mom continue to maintain these children on Molina, correct?
Yes.
And that it states to base her child support off of minimum wage. However, if the calculation is based off her income information that you provided, you'd be okay if that's what the child support calculation would be, is based off her income that from the evidence you provided.
Yes.
Other than that, the proposed parenting plan, other than the child support and health insurance request that you just modified right now, the rest of the parenting plan you're asking to be granted in full, correct?
Yes.
I'll pass the witness, Judge.
Okay. Sir, I have a question for you. In your proposed parenting plan, you recommended the court ordering her to have supervised visits at Hannah's house.
Yes.
Would you also like for it to for her to be responsible for the cost associated, or are you going to be associated with those costs?
If she can help out a little with that, that would be appreciated.
Okay. Thank you. That's all the questions that the court has. Anything further for this witness?
Nothing further for this witness, Judge.
Thank you. Sir, you may return to your seat next to your attorney. Attorney Cantu?
Judge, I guess just briefly call myself on attorney's fees.
Okay, go ahead.
Thank you, Judge. I've been practicing law for about 8 years now in the Dallas-Fort Worth area. This has been a case that didn't have to be as difficult as it was. We were hired on back in 2024, initially for a modification case. We charge our clients by tasks, but we do have hourly rates. Willie actually appeared for the first hearing in front of Judge Aguilar, wherein the problems started, where mom had already left, absconded, and then was told to come back. At that point, Mr. Meda had to pay us additional fees past the one fee that we thought he was going to have to pay. And we had a reset hearing in October, which I appeared, mom didn't, and we had a default hearing. We then had a pretrial that he paid for, that we appeared and mom appeared. And after that, there were several hearings, Judge. I believe it's on the court's docket. We had a status hearing where mom did not show. We had a jurisdictional hearing with courts in judge in Philadelphia, motions filed by my office to get that accomplished. We had to present Judge with an order for the children to be returned through a writ, which he paid me to file and execute. We had 3 different temporary orders set, 2 of which had to be reset because I simply wanted mom to appear or her attorney to appear. They wouldn't. We finally had to take another default on May 27th of 2025. We appeared for a pretrial. We had to file a motion for protective order against mom and her request for discovery in August. We appeared recently to the exhibit conference with a no-show, and we're here today, Judge. I do charge at this point $450 an hour. I believe my contract with my client was $285 an hour, but we do charge by the task. I believe with all the hearings, all the motions we've had to present, that he has paid us a reasonable fee, including trial today of $20,570, which is more than he was estimated at, simply because these kids were taken away from him, from their home, and required a lot of additional hearings, some of which didn't need to happen because mom was dishonest with the court and dishonest with the Philadelphia courts. So I believe that those attorney's fees are reasonable, Judge, and I'll pass myself as a witness.
Okay. Attorney Smith, any questions for Attorney Cantu?
Just a couple briefly.
Go ahead.
Mr. Cantu, you had stated that you bill your client, or your contract with your client is for $285 an hour?
Yes, sir.
Okay. And is that what you billed him at that rate throughout this case?
No, sir. As I stated, we have an hourly rate, but we charge our clients by the task. So in our contract, each motion, each trial, each appearance, there is a estimate of what it will cost, and that's how we charge our client. But for purposes of itemizations, breakdowns for court purposes, we have an hourly rate.
Okay. And the $20,570 that you have presented to the court today, is that based on the task structure, or is that based on the amount of hours expended and applied to the hourly rate?
The tasks, yes, sir.
Okay. No further questions, Judge.
Okay. Attorney Dale?
No question.
All right. Attorney Cantu, you may call your next witness.
I have no further witnesses, Judge, and we rest.
Okay. Attorney Smith?
We have no witnesses, Your Honor. Rest.
Okay. Attorney Dale?
State has no witnesses.
All right. I have a question for the state. The arrears that Mr. Maida is requesting in the amount of $2,023 in child support for mom, do you have an as of date?
I do not.
Okay.
I would assume that would be correct. So October 22nd.
Okay. Thank you. And Attorney Cantu, the $3,000 that were previously ordered, are you asking that to be added into the 20,570? Or because I would think it needs to be cumulative.
I think you're right, Judge. I had separated them only because I didn't want the judge to see that I had included it as a part of the attorney's fees. They were already ordered, but yes, they should be one judgment of, I guess, the 23,570.
Okay, thank you. But the 20,570 is what you're requesting be paid to your office. Well, the 3,000 is to your office as well.
I'd want them both to Mr. Maida, but I have them paid at my office.
Okay,
Yes.
I got it. Thank you.
I do want them awarded to him.
All right. Anything further?
Other than that, Judge, I do have a proposed order for the de novo hearing that I would like to present.
Yes, please.
May I approach you?
Yes. And thank you for giving me a proposed order. I like to sign those just to keep the record clean. And I'll get this turned in. All right, so the court is going to grant father's request in father's proposed parenting plan. The court grants it in its entirety. The court would also like it to be added that mother shall be responsible for the cost, solely responsible for the cost with supervised visits at Hannah's house. The amount of attorney's fees is granted too. That's a cumulative judgment in favor of Mr. Maida in the amount of $23,570. The court is confirming their judgment. The court is also confirming the judgment of child support arrears in the amount of $2,023 against mom as of October 22nd, 2025. And the court accepts the agreement, the payout rate that was recommended to the court for mom to satisfy that judgment. Is there anything further?
No, Judge, I assume I will do the order, so I just will make sure I get it out to Mr. Dale and Mr. Smith.
Okay, and about that, how much time do you need? I can go ahead and set you on a dismissal / entry date.
I would prefer if we could, Judge, the last week of November. I know that's Thanksgiving, but I do have paternity leave coming up. I could do it by November 24th.
Okay. Let's just do this because the 28th, that coming up Friday after that is a holiday. So let's push it to December the 5th. So of course, if you all get the order to the court before then, you know, you don't have to worry about that date. But in the event that you don't, you have to show up to that date, and the dismissal docket is before Judge Lee. And her Zoom code is 961-1106-4392. That's in the event you need it. You all may not need it.
Thank you, Judge.
All right. Thank you so much for your time.
Thank you.
Thank you. We're off the record. All right, and the court is in recess until 1:30.
Judge, can I ask a